Hello, good afternoon. Welcome to today's webinar. My name is Matt Kissling. I'm a partner in Thompson Hine's Labor and Employment Practice Group in our Cleveland office. I'm also joined here today by my colleague Hannah Caldwell, who is an associate from our Cleveland office, also in the Labor and Employment Practice Group. Today we will discuss the current state and federal guidelines regarding cannabis in the workplace, including drug testing developments and trends, accommodation requirements, best practices for crafting and implementing employment policies, and compliance with federal contracts and drug-free workplace requirements. Before we begin, I just want to cover a few housekeeping items. First, today's program is being recorded, and we will send a link to all attendees, including the presentation slides, within 48 hours of today's presentation. And if you have any questions during the webinar today, please feel free to use the question box located in the control panel on the right side of your screen. We'll make every effort to answer as many of the questions as we can at the end of the webinar. If we're not able to get to your question, I will make sure that someone from our team follows up with you within the next week or so. Once again, thank you for your interest in attending today, and now we'll begin.
Okay, thanks, Matt. So as Matt mentioned, everybody, I'm Hannah Caldwell. I'm looking forward to having this conversation with you today. And I want to start off because I am absolutely certain that no one on this call has any familiarity with marijuana whatsoever. I want to get some key terms out of the way. So marijuana is sort of this big umbrella term that we use to describe a bunch of components of the cannabis plant, so the dried flowers and leaves of the cannabis plant. And so there are a couple components we need to keep in mind here when we're talking about ways in which we regulate and treat different components of marijuana. So first things first, perhaps the most wild and crazy element of the cannabis plant is THC. Specifically, Delta-9 THC is the component in marijuana that has psychoactive compounds. It's the component in marijuana that gets you high. And then you've probably also heard of hemp and hemp products. Hemp can be sort of a big bucket in this family that can be any part of the cannabis plant. That can be seeds, derivatives, extracts. And as long as it has one of those Delta-9 THC levels of 0.3 or less, it can be considered hemp. And hemp was actually removed from the Controlled Substances Act as part of the 2018 Farm Bill. And we'll talk a little bit more in a while about why that is significant. So I have a little pop quiz for you. The first question that I will ask you today is marijuana legal? So that's kind of the underpinning of our whole conversation today. Is marijuana legal? There are a lot of conversations happening in Ohio and at the federal level for people to understand sort of, is marijuana legal or is it not legal? And so, unfortunately, in a real lawyer answer for you, the answer is yes and no. And it's yes because, as you probably understand, recreational use has been legalized in 24 states in Washington, D.C., and that now includes Ohio, which we'll talk a little bit more about in a minute. Medical use of marijuana is permitted in 38 states and D.C., and other states have decriminalized its use. And as you probably understand, this landscape is rapidly evolving because every year we see more states legalize or be expected to legalize or decriminalize marijuana over the next few years. But the answer is also no. And as my colleague here, Matt, will talk to you about in a little bit, the federal regulations still classify marijuana as a Schedule I substance under the Controlled Substances Act. And so by way of background, Schedule I substances are considered to have a high potential for dependency and no accepted medical use. So that makes the distribution of cannabis a federal offense. A little bit of a development is that earlier this year, the Department of Health and Human Services sent findings on marijuana to the DEA, or the Drug Enforcement Administration, reportedly recommending that marijuana be reclassified as a Schedule III drug. Now, that classification would mean that the substance has a moderate to low potential for physical and psychological dependence, but it's yet to be seen if there will actually be any movement. And so this slide is one of my favorites, the map you can see on the screen, because it's the slide that Matt and I have to refresh most often, given this rapidly changing landscape. One thing I wanted to mention also is that even if marijuana is reclassified as a Schedule III substance, it would still be a controlled substance, subject to federal rules and regulations that Matt will describe in a moment. It also would not be immediately legalized for recreational use if it was reclassified at the federal level. And rescheduling doesn't decriminalize marijuana either. The reclassification to Schedule III would open the door to more research, though, because it's easier to study the effects of Schedule III drugs than Schedule I drugs. And what about CBD? I get this question a lot. I'm sure that you have been to a corner store or a grocery store and you've looked at the shelves and seen CBD gummies or CBD dog treats or CBD lotions and thought to yourself, hey, what's going on with that? Is this considered a marijuana product? And you know, the answer is yes, it's hemp derived, so long as that active THC is less than 0.3%. So it's generally viewed as federally legal because there are non-psychoactive components at that level of delta 9 THC. And the FDA also just recently announced that it's not in a position to properly regulate CBD, though it's still subject to some of the FDA restrictions and regulations on labeling and marketing, being included in food that you ingest, your dog treats, cosmetics, lotions, and stuff like that. And again, the common theme here and the very frustrating lawyer answer here is that it's also subject to varying regulation by the states. So, you know, for example, in Ohio, CBD is legal and there's no legal age restrictions to purchase it. Vendors are still able to set their own rules regarding the sale, and some do require that customers be at least 21 years of age to purchase CBD. But that's another wrinkle in the varying state laws in that in some places it's totally unregulated, in others it is restricted. So what does that mean for you? You know, obviously the cornerstone of this presentation today is that, you know, the laws regulating these various components of the marijuana plant and cannabis generally, they vary by state significantly. And some employers also need to adhere to federal compliance and regulations regarding drug testing and workplace policies. And, you know, as Matt's going to describe in a moment, that landscape is also changing rapidly.
Thank you, Hannah. So let's talk about where federal law currently stands on drug-free workplace, drug testing, and specifically related to marijuana and cannabis. Because of course, under the supremacy clause of the Constitution, if any state law were to be inconsistent with the requirements of federal law, employers would need to comply with federal law and essentially disregard what the states say. So initially, the important point here is that there's actually no general requirement for most private employers in the United States to have a drug-free workplace policy of any kind. Now, there are, as Hannah mentioned, a few exceptions for certain businesses that are federal contractors or subcontractors, as well as federal grantees, as well as some very specific safety and security sensitive industries and positions. Now, the one thing to note here is that even though there's no general drug-free workplace requirement, we do need to consider other potential federal laws that may come into play. So we see OSHA here, you know, the employer's general responsibility to maintain a safe and hazard-free workplace. The Americans with Disabilities Act, you know, some things to think about here is that first, an employee with a history of substance abuse, someone who is not currently using illegal substances, but that having that history of abuse can be considered a disability under the ADA, as well as most corresponding state disability discrimination laws. So what that means is that an employer may be in a position where you would potentially need to accommodate someone who has recovered from a substance abuse issue, but is not currently actively using. Another wrinkle from the ADA perspective is providing an accommodation for an employee to undergo substance abuse treatment and how to address with them when they're potentially ready to return to the workplace. Also considering accommodations for employees who have other medical conditions where marijuana or cannabis may be prescribed as a form of treatment. How do you balance your obligations under the ADA with other drug-free workplace considerations? So some of the things to think about from the FMLA. Again, someone who is receiving treatment for substance abuse could be considered to have a serious health condition, who would then be eligible for the 12 weeks of unpaid leave under FMLA, as well as any corresponding state leave requirements. And again, the consideration there is, how do we balance our interest in having a drug-free workplace with meeting these federal obligations? Now, as I mentioned before, there is one key exception to that general lack of federal movement on drug-free workplace, and that's for federal contractors and grantees, where certain contractors and grantees are required to comply with the Drug-Free Workplace Act of 1988, which generally requires federal agency contractors and grantees to certify that they will provide a drug-free workplace as a precondition to being awarded a contract or a grant from that federal agency. As Hannah mentioned before, federal government still does consider cannabis to be a controlled substance that's illegal under federal law, alongside other drugs such as heroin and methadone, and are therefore subject to the rules under federal law and the general prohibitions. Now, the Drug-Free Workplace Act applies to any company or organization that receives a federal contract or subcontract of $100,000 or more, as well as any organization that receives a federal grant of any size. There's really no dollar threshold for the federal grant to trigger the Drug-Free Workplace Act requirements. One thing to think about is, while the Drug-Free Workplace Act generally requires you to have and maintain a workplace free of illegal drugs and alcohol, it actually does not require you to conduct testing. Another important wrinkle is that the Drug-Free Workplace Act does not actually provide an absolute defense to complying with state-specific restrictions on drug testing. A government contractor tried this argument in a Connecticut federal court a number of years ago, and the court specifically rejected that defense and pointed to the fact that the Drug-Free Workplace Act does not require testing, and so they could not rely on that law as a defense to, in that case, discriminating against applicants for off-duty cannabis use that they found out about through pre-employment drug testing. So the key takeaway here is, if you're required to comply with the Drug-Free Workplace Act, that does not allow you to simply disregard state law that may protect someone who uses medical or recreational marijuana or cannabis. So outside of the Drug-Free Workplace Act, there are some other more stringent requirements that apply to some safety-sensitive industries, and this is covered by the Omnibus Transportation Employee Testing Act. And what it does is it requires drug and alcohol testing of all safety-sensitive transportation employees in aviation, so your pilots, trucking, railroads, mass transit, pipelines, and other certain transportation industries. And regardless of whether the employee is in a safety-sensitive position or not, the employees must receive drug and alcohol awareness training and education as part under this particular law. So the Omnibus's requirements do apply to businesses that are regulated by several different federal agencies. So the Federal Aviation Administration, so your airlines or other airport providers, the Federal Motor Carrier Safety Administration, so your trucking companies, Federal Railroad Administration, the railroads, the U.S. Coast Guard, which would likely cover shipping companies, here in Ohio, or Cleveland, companies that have ships on the Great Lakes, the Federal Transit Administration, the National Highway Traffic Safety Administration. So that would potentially cover other transportation companies that are covered by those laws, as well as the Pipeline and Hazardous Materials Safety Administration. So companies that are transporting those hazardous materials or assisting in transportation and assistance of the pipeline system. Yeah, and another area where that's regulated from a drug testing perspective is actually for organizations that contract with the Department of Defense. And here it's a regulatory requirement. And what the regulations say is that any DoD contractors who have access to sensitive classified information, so basically jobs that require security clearance, are required to adopt and employ drug testing policy. Now, the interesting thing here is that the DoD regulations include a specific carve-out that says testing requirements do not apply to the extent they are inconsistent with state or local law. And so if you're covered by these DoD regulations, unfortunately, you still do need to think about what does state law have to say about drug testing, in particular for marijuana or cannabis use. Another security-sensitive industry where testing requirements apply are businesses covered by the Nuclear Regulatory Commission and their fitness for duty requirements. And these generally apply to operators or builders of nuclear power plants, as well as certain entities that possess, use, or transport nuclear material, and certain contractors and vendors who support those types of operations. And what the regulations say is that all covered entities do need to implement fitness for duty programs that provide a reasonable assurance that individuals are not under the influence of any substance that could adversely affect their ability to safely and competently perform their job duties. Obviously, that's pretty important if you're dealing with nuclear energy and the potential consequences if that type of material is not handled properly. And the fitness for duty programs do specifically require procedures to enforce an alcohol and drug-free workplace, including implementation of drug and alcohol testing as part of the drug-free workplace. The regulations require testing in a number of different circumstances and specifically identify marijuana metabolites as something that needs to be tested for as part of the panel. And in these situations, testing is required for pre-access to any facility, so before you can send your workers to a nuclear facility, for cause, which we generally consider to be kind of the reasonable suspicion testing, post, as they call it, human error events, not necessarily accidents, but other quote unquote human errors or mistakes that could raise a question as to whether someone's under the influence. Follow-up testing, so for someone who's already been tested under circumstances, as well as randomized testing, where employees do need to be selected at random, but the selection process does need to ensure that no protected classes are being disproportionately identified for testing. So if you're subject to these nuclear regulations, there are specific drug testing requirements in place that would supersede any differing state laws. So looking at outside of these different federal regulations and mandates, we've also seen a number of employers, Amazon's a good example, who have actually started to take small steps towards reducing pre-employment drug tests in particular for jobs that aren't necessarily regulated by the federal mandates. A big question here is, why are they doing this? Is it because are they due to rapidly changing state laws surrounding marijuana legalization? We're simply giving HR a headache. Is it eliminating pre-employment testing for marijuana allowed Amazon to expand its applicant pool? Or is it a combination of the two? And here it's actually, for Amazon, it was a combination of the two. They were actually subject to a lawsuit in a federal court in Pennsylvania, where the plaintiff alleged that he was a certified legal user of medical marijuana in Pennsylvania, and he claimed that Amazon was in violation of Pennsylvania's Medical Marijuana Act for its refusal to hire him on the basis of an alleged failed drug test that came back positive for marijuana. And under this theory, he's inciting to Pennsylvania law. He relied on the fact that the state's Medical Marijuana Act specifically protects workers from this type of employment discrimination with little to no exception. And so because Amazon, that situation was testing, that opened them up for potential legal liability under state law that protected medical marijuana use. So obviously, these various federal impacts, that require testing, it do have industry impacts, across the United States, and the transportation industry is a pretty good example. So Hannah put the slide together of this report from the American Transportation Research Institute that evaluated the impact of marijuana legalization on the trucking industry. Now, of course, the trucking industry is subject to those specific DOT and Motor Carrier Association fitness for duty requirements, including having negative drug tests in order to be qualified to drive a commercial vehicle. What this particular study showed was that from 2020 to 2022, more than 100,000 truck drivers tested positive for marijuana through the clearinghouse, and they were then removed from duty in accordance with DOT requirements. Now, while these drivers may or are permitted to return to work after taking, as the study put, a series of remedial steps, the report did claim that the positive test contributed to a perceived driver shortage in what is already recognized to be a pretty tough labor market for qualified truck drivers. Now, in response to this study, 62% of carriers surveyed actually favored changes to the federal drug testing policies, and 47% called for a sobriety or impairment test to help distinguish between drivers who use marijuana recreationally and those who are under the influence while on duty. And so, to date, in response to say, we really haven't seen any sign from the federal government that they're interested in changing the current testing requirements, but it is an interesting study showing kind of the downstream effects of these specific federal requirements regulating marijuana use in the workplace. So now I'm going to turn it back over to Hannah, where she's going to jump into the state and local laws that may be substantially different from what the federal government requires.
Thanks, Matt. And, before I advance this slide, I'd like to point out how funny the pun in this slide is, hashing out state and local laws. We have gotten a good laugh out of that. But I've got good news and bad news for you in response to what Matt just said. The good news is that many states have given us a framework, have given us guidance and statutes, regulations, case law, et cetera, on how individuals in that state and businesses in the state are required to treat adult use of marijuana and medical use of marijuana. But the bad news is, to the extent you are operating in multiple states, the state laws vary tremendously. So it's really important that you have a solid grasp on where your workforce is and which states' laws apply to you. And I guess a good primer is Ohio recently saying yes to cannabis with issue 2. And so, Matt and I have received a lot of questions on saying, okay, great, what does that mean for our business? And so before I get into that, if you've been living under a rock for the past couple months, I'll lay down the basics for you. Ohio obviously joined 23 other states in DC in legalizing adult use recreational marijuana. And so as of December 7th, the effective date, it's legal for Ohio citizens to possess and consume cannabis recreationally. So as passed, the law gave Ohio 9 months to set up a system for legal marijuana purchases subject to a 10% tax, with revenues to be divvied up between administrative costs, addiction treatment, municipalities with dispensaries, and social equity and job programs. And so non-medical sales are not expected to begin until around September 2024. And that's due to that 9-month grace period to allow the state to set up a system for regulation. And certainly the Ohio legislature is undertaking efforts to potentially modify the language of issue 2 via statute, which could theoretically and substantially affect consumer and employer rights down the road. And it's worth noting that Ohio's top cannabis regulator, the Ohio Division of Cannabis Control, recently said that they anticipate there could be up to 250 to 300 marijuana dispensaries selling product for adult use by September 2026. And the reason I think that's notable is, these efforts to make adult use cannabis more accessible, to legalize and regulate consumption in this state certainly adds to accessibility and will certainly add to headaches around shearing up policies in the workplace. But as of right now, what does issue 2 mean for you as an employer? Not a whole lot, right? So issue 2 is drafted consistently with Ohio's treatment of medical marijuana. So that means that users of adult use cannabis, notwithstanding the legalization efforts, are not entitled to job protection. The law in Ohio has no requirement for employers to accommodate adult use of cannabis. And employers are free to continue to set and enforce their own rules regarding hiring, testing, and disciplining employees based on a positive test. But issue 2 aside, it still isn't the wild, wild west in how we want employers to be thinking about marijuana and treating employees who come to them with issues related to cannabis. The overlap of off-duty marijuana use and employment is complex. So we're going to dive into each of these points a little bit more in a moment. But as Matt already mentioned, employers absolutely must evaluate whether they're bound by federal regulations that mandate marijuana testing, and whether those federal regulations have any carve-outs set aside for state law considerations. Employers need to understand, hey, listen, do we receive a workers' compensation discount for our efforts to test for marijuana and maintain a drug-free workplace? Are we going to continue pre-employment testing? Because will it limit employer hiring? So in a tough job market, is our applicant pool deep enough for us to continue testing adults for marijuana? And perhaps most crucially is understanding, hey, are our managers and HR personnel sufficiently trained to implement what is written in our drug-free workplace policy or in our other policies related to reasonable suspicion testing, pre-employment testing, and things of that nature, so we can make sure we avoid any problems by treating everyone consistently under our policies, state by state. And the conundrum continues, people. Some of the key issues that we'll talk about that vary widely by state are a little bit surprising to people. Something as simple as, can we even test applicants and employees for marijuana in this state? And as Matt and I will talk about in a moment, in some places the answer is no. What can we do to act against an applicant or employee if they have a prescription for or are using medical marijuana, and that, on the face of our policy is inconsistent with our company values? Are there any concessions that we have to make under state law? It depends where you're at. Sometimes the answer is yes, sometimes it's no, sometimes it's maybe. And, are we allowed to take adverse employment action against an employee who is using cannabis off duty? In some places the answer is yes, sometimes it's no. And so to avoid any issues related to these varying state laws, it's really important, like I said before, and I'll reiterate approximately 100 more times, that your drug testing policy needs to be clear and consistent so that your internal folks understand who, what, when, where, and why we are taking action against employees for the use of adult use or medical marijuana. So let's talk about that who, what, when, where, and why. I'll start with a very basic one. Who can we even test? Like I mentioned before, many states have mandatory state drug testing rules that apply to private, non-regulated workplaces. So these are distinct from some of the regulated workplaces that Matt touched upon a moment ago, in that they apply to private businesses. So for example, in New York, employers are prohibited from testing current and prospective employees for marijuana outright, full stop. In other places, prospective employees are limited, and in some places, adverse employment actions may not occur based on just a positive marijuana test result. So if you have operations in multiple states and pre-employment is part of your drug testing procedure, it's really important to understand that, hey, listen, in some places, it's not appropriate to test prospective employees or current employees. And I'm gonna give a little primer to this, and then Matt's gonna get into more detail, but this seems like a silly question for what can we test when we're talking in a presentation that is centered solely on marijuana and cannabis issues. But in some places it's actually a really important question. What can we test? And the reason is because unlike testing for alcohol, which is a really accurate measure of blood alcohol content and applies directly to impairment from alcohol, there's no test for marijuana that can tell us, is this individual high right now at the time of the test? Is this person impaired? So there's no test that can tell us actual impairment number, because there's no, quote, BAC for active delta-9 THC. That just does not exist. Cannabis, as I'm sure none of you have any experience with, affects people differently based on their body composition and based on their frequency of use. And so, some states have seen this as a big problem and have decided, hey, listen, this is a problem if we're testing people who are not actually intoxicated, and we're going to start treating cannabis like alcohol.
Yeah, so states in addressing that issue, we've seen them take a couple of different approaches. So let's talk about New York first, which is really one of those states that tend to give us labor and employment attorneys a significant degree of heartburn whenever we're talking about regulating what employers and can or cannot do with workers in the state. So as Hannah already mentioned, the New York labor law, section 201D, specifically prohibits employers from discriminating against the legal use of cannabis outside the workplace and during non-working hours. This adds to the laundry list of protected classes of employees under New York law, which, as you may know, also generally prohibits employers from taking adverse action against candidates because of a background check or criminal background check, unless you do a specific enumerated factor analysis to determine whether or not the conviction should actually be disqualifying. But jumping back to drug testing, New York also generally bars employers from testing for marijuana or cannabis unless an employee shows, as they put it, specific articulable signs of impairment that either decrease job performance or pose a threat to workplace safety and health. They're probably asking, what are those articulable symptoms? According to the New York Department of Labor, these must be objectively observable signs of impairment while at work. And so it's not something where you can simply say, well, I think this person's impaired, or accepting, from word of mouth, someone else who comes and tells you, I think, Joe Smith is high on the job. And according to the DOL, you can't test for cannabis or marijuana absent signs of impairment, even if federal law otherwise permits it. So as Hannah mentioned earlier, this effectively prohibits pre-employment testing in any situation, and really provides a good example of how a state law potentially interacts with an employer's Drug-Free Workplace Act or obligations under federal law. But at the same time, the New York DOL also specifically says if federal law requires it, so you're in one of those safety-sensitive industries where it's specifically required, you are allowed to test for marijuana or cannabis for employees and candidates. So jumping to another state that gives us heartburn on a day-to-day basis from an employment perspective, let's look at California. They take a bit of a different approach here. So again, they do protect the rights of recreational marijuana users outside of work, and at times when marijuana use will not affect their work performance. And they also make it unlawful to discriminate against an applicant or an employee who has engaged in the lawful use of marijuana outside of work. And this new law did take effect on January 1st of 2024. But California also does something different. They also prohibit employers from relying on tests that measure only cannabis metabolites rather than the active THC that Hannah mentioned before. According to California, metabolites in and of themselves will not demonstrate that the individual was impaired at the time of the testing. It said it could be a situation where the employee legally used marijuana a couple of days before, over the weekend, or while they're on vacation. They come back and it's still showing trace elements in their system. In that situation, California says you can't test for that, and you can't use that as a basis to take an adverse employment action against an individual. So by way of example, according to California, hair and urine specimens which measure cannabis that is not metabolically active, while certain saliva and oral fluids and blood tests can measure the psychoactive TH components in the individual's system at the time of the test, you as an employer really need to make that distinction when you're talking to your testing companies and deciding whether to test someone for potential impairment. So what's the takeaway here? Obviously in some jurisdictions, a positive test for marijuana metabolites will simply not tell us enough. So you as employers, if you operate in multiple states, you do need more than a positive test to determine the level of an employer or candidate's impairment. So for instance, finding a joint or noticing and documenting that an employee is visibly high at work. Again, jumping back to what New York says, what are those articulable objective signs of impairment that tell you, look, this employee is actually under the influence of something while at work, whether it's marijuana or another substance. So with all that in mind, let's take us to the next question. When can we test? And again, this is an area that is, regulated, by state law unless a different federal law applies. So often we see, employers test at the pre-employment stage, upon a conditional offer of employment as part of the normal onboarding process. Again, New York is the first state in the country that to generally prohibit employers from doing so. We also see, employers undertake randomized testing. Again, as I mentioned earlier, even if this is required by federal law, employees do need to be scientifically selected to avoid what we in the employment universe call an adverse impact or a disparate impact on a particular protected class, which if that occurs, that creates a whole different set of issues, other than complying with state drug testing laws. Often see, for employees who operate machinery or have a significant amount of driving as a key part of their day-to-day duties, post-accident testing. And it's important in the policy to define what constitutes an accident that would potentially trigger a post-accident test. Reasonable suspicion or for cause testing, again, need to make sure we're mindful of state law when we're defining conditions of what constitutes reasonable cause versus what not, and who can actually make that determination. It's usually a situation where we highly recommend involving human resources in that discussion. And when you're talking about reasonable suspicion or cause, one of the key questions to ask ourselves is, do we have enough to discipline this individual because we think they're not performing the essential function of their job? Is there something else that out there that's telling us this person may be impaired while at work? And if the answer is no, then maybe a situation where conducting a test is not going to be justified. Again, we need to look at symptoms that provide objectively observable indications that someone's performance of their duties or tasks of their position are being impacted because they're under the influence. Often we also see drug testing conducted from a return to duty perspective. So following a failed drug screen, if that person's going to be allowed to return to work, as well as if someone is coming out of substance abuse treatment, are they coming back under what we call a last chance agreement, whereas as a condition of their return, they have to agree to return to duty and potentially randomized drug testing. Again, it's an area we need to be mindful of both federal law from an ADA perspective as well as any state restrictions. And then finally, we often see testing as we call follow-up testing, where you basically agree to a series of randomized drug tests. And this usually is only triggered if one of these other categories of testing has already been conducted. So, when talking about, when can we test, the other question is, where can we test? And of course, state law, does tend to differ in situations on which parties, may collect the specimen or conduct the actual testing of the specimen. So is it a situation where, the employer themselves is allowed to do it, or do you have to send, that individual to, an outpatient clinic or an occupational health facility to have the testing done by actual nurses or other medical personnel? Typically, we don't recommend that you as the employer conduct the testing yourself. Instead, the safer bet is to farm it out to a third-party organization that has personnel who are specifically trained on how to conduct these tests in a compliant manner. Many states also require employers to use a medical review officer in the test process who's going to actually review the results and typically enable an employee to provide an explanation for why a test may come back positive. An example I always like to use is, let's say for a holiday, someone brings poppy seed roll and for dessert, and someone has a piece, and then they're subject to a randomized test the next day, and they come back positive for opiates. They didn't actually use heroin or another opioid. Instead, they simply ate a piece of poppy seed roll, which as a huge fan of poppy seed roll myself, I can tell you it's hard to turn down. So that's a situation where, are we providing this employee to provide an explanation for why they may have come back positive? And that's where a medical review officer really comes into play, as well as the MRO determining how the actual lab specimen got from point A to point C, from the laboratory to the analysis to the final conclusion, to make sure that that chain of custody hasn't been disrupted or potentially compromised, to ensure that it's a clean test and that the results are clean in of themselves. So again, this is something we need to be mindful of state law, because it may require an MRO to be involved in the testing process. So we've talked about the who, what, where, and when. That takes us to the next question: why should I test? An important advantage is to enhance the productivity, health, and safety of the workplace. Again, as employers, we do have general obligations and an interest in maintaining a healthy and safety workplace for all employees. We operate in a state that potentially provides some form of immunity for testing, where some states do have laws that provide you with limited protection from litigation, and provided that you do have a drug and alcohol testing program that's established and maintained according to states' rules. Obviously, again, need to pay attention to which states may have this and what states may restrict it. You may also have certain financial incentives for testing employees or applicants. Some states, and I'll cover this in a little more detail on the next slide, do provide discounts on workers' comp plans and potentially insurance, liability insurance. And it may also provide a rebuttable presumption of intoxication for an employee, where if they come back positive on a test, then it's their job to explain, potentially why, that test came back positive and why adverse employment action shouldn't be taken against them. So let's talk about, potentially saving money. So, here in Ohio, the Bureau of Workers' Comp actually offers a 4 to 7% premium rebate to eligible employers for implementing a drug-free workplace program. That does include drug testing as well as drug-free workplace education for employees. Now, what the BWC requires is that the employer does need to provide pre-employment or new hire, reasonable suspicion, post-accident, return to duty, and follow-up testing. And this includes testing for marijuana. So obviously, this is Ohio. As Hannah mentioned earlier, even with issue 2 passing, it still doesn't necessarily regulate what you can or cannot do in the workplace when it comes to marijuana testing. And the Bureau of Workers' Comp's stance on this reflects that. Obviously, you're not going to see this in other states like New York or California that specifically restrict testing. But again, if you're in a state that tends to be more employer-friendly on this front, it's something to look at. Can we get a workers' comp rebate by having an effective drug testing program in place? So regardless of which state laws we look at here, which again tend to differ across the country, there really are 2 things that are certain. In every state, it is still allowable to have a policy that specifically prohibits the use of marijuana on the job, as well as any other substance, alcohol, or any other form of drug, and also prohibits an employee from being impaired while on the job. It's just the question we have to ask ourselves, and when we cross state lines is, how can we make that determination of impairment, and what steps do we need to take, to make sure we're legally compliant when we're addressing those situations. So I'm going to pass it back over to Hannah. She's now going to talk in some more detail about, how do we manage medical marijuana in the workplace.
Thanks, Matt. So yeah, so we've spent a lot of time now talking about adult use. And I know what you're thinking. Wow, I would really love to hear about another wrinkle in this scheme that's going to cause me a headache on how I need to manage my approach to marijuana. Well, I've got good news. I've got more wrinkles for you. And what I'll say is, just like adult use cannabis, state law also differs on what employers' obligations are with respect to medical marijuana users. So, as I mentioned before, in some states like Ohio, employers are not required to provide accommodations for medical marijuana users. Certainly, they're not allowed to allow an employee to work under the influence of marijuana, which is true in every state. But in some other states like Illinois and Pennsylvania, employees cannot be discriminated against for being a registered marijuana card holder or because they test positive for marijuana on a drug test due to their protection under the state's medical marijuana scheme. And so, some states explicitly require employers to go through this reasonable accommodation analysis with employees to determine, is there anything that we can do to accommodate your use of medical marijuana under the state scheme? And, more recently, plaintiffs have been relying on these state-specific disability discrimination laws to file lawsuits against employers for their failure to accommodate their use of medical marijuana and for disability discrimination. And, they appear to be gaining traction based on the number of lawsuits that we're seeing come through the door. And so, as I'll give you some more strategic feedback on in a moment, in light of these discrimination laws with plaintiffs coming to court and saying, hey, listen, I am using medical marijuana outside of work. I was not inebriated at work, and my employer was unwilling to talk to me about it. It's even more important than ever that, in every state, employers make sure they have a clear policy and procedure for addressing and responding to accommodation requests from applicant and employees. And so, for everyone on the call, it's important that, after a positive test, you do something about it, right? So, if an applicant or employee tests positive for marijuana and claims, oh, look, I have a medical marijuana card for a bona fide disability. Step one is know the rules of your state, know which rules apply to, this particular operation, this particular employee. Like I said, in Ohio, that first step would say, hey, listen, Ohio doesn't require accommodations. But it's still important to think about, what does our policy say? Have we made any representations that, we're going to be engaging in the interactive process to address the underlying disability? Or has our conduct in the past with other employees who have brought up similar issues, are we going to treat this person consistently with that past conduct? And so again, that analysis says, is medical cannabis even legal under state law? Is there a law that prohibits termination for medical marijuana use? Is there a law that requires me to accommodate medical use? And in certain circumstances, if the request for accommodation occurs after the policy violation, meaning after your HR person documented observable objective symptoms of intoxication or a failed drug test, that's not really a request at all. It's sort of a response to a policy violation. That's something to consider. And really understanding, what does our written policy say? What is the guidance we have on this point? And, regarding off-duty medical marijuana use, some states affirmatively protect a patient from adverse employment action due to off-duty use, right? So, usually, as Matt described before, the only exception to this would be, if the employer would lose federal benefits for permitting off-duty use, or if it would be some sort of regulatory violation. And so a lot of the questions I get are, okay, Hannah, that's all great. That's all well and good for us to engage in that accommodation analysis, just like we do with folks who have other types of disabilities we're thinking about accommodating. But what does that actually look like for cannabis users? And so it could look like a couple things. One example is permitting off-site drug use outside of work. So in somewhere like Massachusetts, an employee's use of medical marijuana outside of work, courts have said may be a reasonable accommodation to an employer's drug-free workplace policy. And again, that's a fact-specific analysis. That is not a hard and fast rule, but it's certainly one of the factors that can be considered as a reasonable accommodation. Another option is to, take a hard look at your existing drug testing policy and say, listen, is there any places where, it would be lawful for us to modify or make exceptions or have state-specific addendums to this policy? For example, in Delaware, an employer is not permitted to assume that an employee is under the influence of marijuana merely because it's detected on a drug test. So what does your policy say about the immediate actions for a failure to pass a drug test? And then third, again, another very fact-specific analysis and industry-specific analysis. But, it's a consideration of, is it possible to move this employee out of a safety-sensitive position while they're using medicinal marijuana under a bona fide state medical marijuana scheme? For example, is it possible to move them from a forklift operator role to a role where they are not operating heavy machinery? That's certainly something that could be discussed internally as a possible reasonable accommodation. Now I'm going to turn it back to Matt to maybe answer some of the questions that you have about these various state and federal laws that we've talked to you about today.
Thank you, Hannah. It's obviously a lot to take in, especially if you do business in multiple states. But what are really some questions that we often see, or have been seeing, on these issues? So first, let's talk about the interaction between federal and state laws. So let's say you're subject to the Federal Drug-Free Workplace Act, but you also operate in a state that restricts testing for cannabis. So a common question we see is, our federal contract requires us to comply with the DFWA, so aren't we exempt from state law requirements? Unfortunately, the answer here is no, because again, the DFWA does not in and of itself require drug testing, in particular for marijuana or cannabis. Now, if there was another federal requirement that also applies in addition to Drug-Free Workplace Act, or even a safety sensitive industry, then we're in a situation where you may be able to consider yourself exempt from state law requirements. Are we still, another question we see, are we still allowed to prohibit or test for marijuana or cannabis? At the end of the day, you are still permitted to prohibit the workplace use or possession or impairment by marijuana or cannabis. Again, the thing we just have to be careful of under state law is how do we go about making that determination in order to be able to take appropriate action? How about another question we see is how do we enforce a drug-free workplace if state law permits recreational use of cannabis? Again, the important thing to remember here is that all states still permit you to discipline an employee if they're under the influence while at work. This is similar to someone showing up to work drunk. If you have those objective signs that they're impaired and you make that determination, then you're still able to enforce your drug-free workplace policy against that person and take appropriate action. So what about if you have clients or customers who mandate testing for your personnel to be able to come on site? Sometimes we see this with government locations, or sometimes you have a client who has a security sensitive operation where they want your employees to be tested and have a negative test before they're allowed to come on site. So here's some of the questions are, who is responsible for the testing? Is it me or the customer? Generally, that's something you probably want to look at the terms of your contract, but usually you as the employer are going to be the individual responsible for the testing. What happens if an employee tests positive? Again, if the client says you can't allow them on site, but you're in a state that potentially restricts on what you can or cannot do, then that's a conversation you may need to have with the client, depending on what the test comes back positive for. What about information sharing and confidentiality? This is something where you also need to be mindful of your obligations under the ADA, under HIPAA, under GINA. What can or cannot we share, with our customers? Is a drug test going to be considered protected medical information? So, those are things we need to think about. And again, at the end of the day, how do we comply with state laws? So the first thing to look at here is the client requirement, due to a federal requirement. Are they a nuclear facility? Are they another safety sensitive regulated organization? If the federal law applies, then you're within your rights to require testing per the client's demand in accordance with federal law. But if there isn't a federal requirement that applies and you're in a state that restricts testing, that's likely something you need to have an upfront discussion with the client about to make sure they understand what the legal restrictions or requirements are, because then it's helpful to make sure not only that you're complying with the law, but also they're doing things in a legally compliant manner. So I know there was a question on this issue. What about how do we manage remote workers? And the specific question was, what if our HQ is in a state where pre-employment testing is legal, but an applicant lives in a state where it's not? The employees are remote. Our organization does not have any actual physical locations in the state. So this is a common question we're seeing in the age of remote work and hybrid work environments. So the questions we see is, when is a home office the workplace? And generally speaking, much like any other state employment laws, you got to focus on the location where the employee is actually performing the work and doing their jobs. And so if you approve someone to do work from home in, let's say, the state of New York, you'll need to make sure that you're complying with New York state law with respect to that particular employee, whether it's dealing with drug testing, drug-free workplace, as well as wage and hour, really any other labor and employment law that you have to think about. How do we determine if reasonable suspicion exists? Obviously, if someone's a remote worker, decreases your ability to potentially supervise their day-to-day activity, but there may still be certain objective signs that something's going on, whether on a Zoom or a Teams meeting, that they seem to be showing signs of impairment. If you suddenly see a significant drop off in their work performance, that could be another issue. Absenteeism could be another potential indication here. Another question we see is, how do we manage testing? If we have that reasonable suspicion, what can we do about it? Here's a situation where if you suspect someone's is impaired, under the influence, do you really want to require them to then drive themselves to a facility to get tested? And so what we often see here is employers will give an employee a certain number of hours, whether it's 24 hours or something else, to go get tested, or even potentially arrange for an Uber or a taxi to pick the person up and transport them to the testing facility. And finally, are we required to accommodate medical marijuana use? Again, we need to look at what state is this employee located in? Do they have the demonstrated proof that they have a medical marijuana card, that they're using it in accordance with the particular state laws? So what about work-related travel? Where this presents an issue of balancing our drug-free workplace program with folks who travel either in-state or out-of-state for work-related purposes. So, well, the big question is, what is work time versus what is personal time? Is it 8 to 5? Is while you're traveling from point A to point B, and making that distinction in your work-related travel policy about what is work time versus personal time. Another question: can we regulate the use of company-provided vehicles? Generally, the answer here is yes. You can prescribe to employees what they can or cannot do while operating company-provided vehicles, and treat that as an extension of being on the job or performing their job duties. Finally, how do we manage conflicting state laws? Well, let's say the employee's home base is in Ohio, but they're traveling to New York, for a sales call. I think here it's a situation where you may need to look at, how frequently does the employee travel out of state as part of their day-to-day job duties? How frequently do they travel to that particular state? This would be a similar analysis that you would conduct, for potentially determining workers' comp coverage if the employee was injured on the job. So it's really kind of a case-by-case, fact-specific question and answers they need to ask yourselves.
And so that brings us to the next topic, which is, okay, understood all of these varying state laws. How the heck do I put together an effective policy that sort of keeps all of these different points in mind? And the first thing I'll say is, drafting these policies can often be industry specific and depend largely on what your business is and where your workforce is. But one thing is consistent across all policies is that they need to have workplace safety, productivity, and inclusivity in mind. And I mean inclusivity of your workforce, and I also mean inclusivity of both federal and state laws that could apply to your particular business. And so, the 5 C's, what a fun slide is this? Here are some things that I talk to clients about every single time they call me about a policy. Create culture. What's important to you? To the extent you're not, bound by a federal regulation, what is the culture of the business? How does the business see adult use of marijuana outside of work, medicinal marijuana? That can sometimes be a business decision depending on what state law says. Clarity. What are violations? What are the consequences? And that kind of leads into complete. You need to understand what behaviors or workplace events actually constitute a reasonable suspicion of intoxication, which would trigger your HR teams or management to perhaps engage with a reasonable suspicion test. Now, does that mean, the employee smells like marijuana, they have bloodshot eyes? They need to be specific and objective signs that managers are trained to identify. Consistent, we need to make sure everyone is treated consistently under your policy. There should be no exceptions for, oral excuses. To the extent we're treating other people differently under the policy, that's not appropriate. And communicate. Review the policy with your employees, repeat it, reiterate, remind everyone, including and especially the individuals that will be responsible for executing under the policy, about what it says. And, policy adjustments, let's say your existing policy calls for immediate termination when an employee fails a drug test. When you're looking at your policy and seeing these state laws and the conundrum we've described today, is it something to have a conversation about internally about revising the policy to allow for some exceptions for either off-duty or medical use? But again, rearing its ugly head are some of those other considerations. But hey, wait, what if the employee is in a safety sensitive position? Perhaps, then the business considers having different drug testing policies that apply to different people with different positions within the organization, but that can get pretty complicated. And I will say that, training management is absolutely key here. Your managers, your HR personnel are going to be the individuals who are responsible for implementing the policy. It is so important that they feel confident implementing the policies and taking action appropriately and feeling confident in the timing and their ability to articulate objective signs of impairment. Again, it's best practice to have 2 management observers when you're doing a reasonable suspicion test to avoid any issues after the fact about, individuals being treated differently under your policy. And again, specific contemporaneous observations concerning things like appearance, behavior, speech, body odor, etc. And if you do decide that your policy needs to make a little bit of room for a medical marijuana accommodation, I can't reiterate enough, be specific, consistent. Remember that safety sensitive industries and other regulated workplaces may not qualify, and keep very detailed documentation of any accommodation requests you receive or that you grant.
All right, so that takes us to the end of our webinar today. I know we ran a few minutes over the 1 o'clock hour, so we do apologize for running a couple of minutes over. And I know there are a few questions still out there. We will be sure to have someone respond to those questions in the coming days. But other than that, we do thank you all for your attention and joining us today. As I mentioned at the beginning, within the next 2 days, you will receive a follow-up email with the recorded webinar, as well as a copy of the presentation slides that you can print off and use for your own purposes. And we do hope that you found the information today to be helpful. And again, we will take steps to address the questions that have been posted during the presentation. But if you have any other questions that come up about any of the material we discussed today, please let us know, or please call or email your regular Thompson Hine lawyer. And if you're not a current Thompson Hine client, then please feel free to contact Hannah or myself to discuss available options where we can address your needs. So again, once again, we thank you for attending, and we hope everyone enjoys the rest of their day.